The views expressed during today's webinar are those of the speakers, not of Stratford, the speakers' firms, or clients, and they are not entitled to provide legal advice. We have gathered an authoritative panel of insurance attorneys who will guide you through the maze of subrogation law, the interplay of state law, and policy provisions and critical issues that arise in apportioning recovery between the insurer and its insured. Our first speaker today is Gary Wickert, a partner at Matheson, Wickert & Lehrer in Hartford, Wisconsin. Our second speaker today is William Merlin. That's Chip Merlin, a partner with the Merlin Law Group in Tampa, Florida. And Gary, if you're ready, if you can get us started.
I am ready, and thank you very much. It's a pleasure to be here. Good morning or good afternoon, whatever the case may be. I'm Gary Wickert, partner and president of Matheson, Wickert & Lehrer, a national subrogation firm located in Hartford, Wisconsin, but I practiced for 20 years out of Houston, Texas. Prior to this, as managing partner of Hughes, Waters & Askenase. I actually see a couple of present and past clients in the attendee list, so I'm glad to have you with us. The subject for today, insurance subrogation challenges for insurers and policyholders, strategies for determining subrogation rights and apportioning recoveries, is an interesting subject. Our firm represents some 250 insurance carriers, self-insured entities from large companies like Walmart and Continental Airlines all the way down to the small privately held companies or smallest local insurers. And subrogation is something we've been handling for some 27 years. We handle it in all 50 states, so we carry with us a rather unique perspective of some of the issues we'll be discussing today from a national perspective. The dichotomy of today's seminar is a little different than a lot of the seminars that we currently give. Toward the end of our session, I'll again put up our website, and if any of the topics are of interest to any of the attendees, we have a series of webinars that we also present that will sort of carry over from the subjects we covered today. Some of those can be watched just live online simply by going to the website. The dichotomy I'm speaking about is that of the insurer versus the insured, the policyholder. And I see from the attendee list that we have both present today. So when we talk about subrogation, I'll be talking primarily about the insurer's interests in subrogation recoveries, apportioning that recovery, effectively planning and strategizing toward maximizing a recovery, whereas Chip will, in many respects, be talking about the policyholders' interests. And it's no news to anyone within the sound of my voice that those interests do not always align. In fact, in many situations, they are adverse to one another. We'll talk about what some of the adversities are and how some of those can be rectified, and hopefully come up with some strategies both for the insurers and the policyholders. So it should be an interesting discussion. I see we have a number of lawyers. I won't belabor the topic of precisely what subrogation is, other than to give you the shorthand definition, which is that it is the substitution of one person in the place of another with respect to a lawful claim, demand, or right. It arises automatically via common law. You don't have to sign a document or have an insurance policy that says you have subrogation rights. In the United States of America, common law it gives us equitable rights to subrogation, which we'll talk about in a moment. The moment you take care of a debt or pay a debt that's owed by somebody, you acquire those rights to recover against another party. The origins of subrogation, I'm always very proud to announce to trial lawyers who think they have hundreds of years of trial law and common law behind them, that subrogation is probably one of the oldest legal concepts known to man. It is much, much older than tort law and dates back to 177 AD with Emperor Hadrian in the Roman Empire. It was first established in English common law in the Magna Carta of 1215. And subrogation today works hand in hand with the concept of insurance and indemnity to ensure that those interested in managing risk are able to obtain both economic justice and that the parties responsible for causing any particular loss are saddled with individual responsibility. The purposes of subrogation are rather interesting, and they tie in with the societal benefits of subrogation. And I spend only a moment on this because no matter what your role, whether you are corporate counsel or you are counsel to an insurer, whether you are an insurer or a self-insured corporation or a company with a large SIR or a lot of deductible plans, it's important to recognize that in our society, I think the benefits of subrogation have sort of been obfuscated and lost by a rather well-funded and well-organized trial lawyers' lobby. One of the chief purposes of subrogation is to place the loss of ultimately any loss, ultimately on the wrongdoer or the tortfeasor who caused the loss in the first place. This is a tremendous goal of subrogation. Subrogation also prevents the policyholder, the insured, from receiving more than he or she bargained for from the contract of insurance. In other words, it prevents a double recovery. If an insured recovers once for property damage from the insurer and then is able to sue a tortfeasor who was responsible for causing the loss, it would amount to a double recovery, and that's frowned upon by almost every state in the country. In addition, another key function of the subrogation doctrine is that it returns the excess or duplicative proceeds to the insurer, who can then recycle them in the form of lower insurance premiums. So, subrogation, in theory, should help keep insurance premiums low. Now, the unusual thing about this seminar is that we're going to talk globally about the subject of subrogation, but we all know that the subrogation nuances vary from insurance line to insurance line. Whether you are involved with health insurance, you are concerned about auto or fleet insurance for your company, if you are mainly involved with property and casualty or workers' compensation, fidelity or surety bonds, the issues that will arise with regard to subrogation differ greatly from line of insurance to line of insurance and then from state to state. So subrogation is one of those areas of the law where you do have 51 different bodies of law, 52 if you count the District of Columbia, that insurance professionals, risk managers, and corporate counsel have to be concerned about. So when we talk about keeping insurance premiums low, I think it's important to mention that, of course, insurance is a plan of risk management or risk sharing. And for a certain price, i.e. a premium, any insured, any entity, any person is offered an opportunity to share the risks of a defined possible economic loss or risk. And since the risk or loss covered by the insurance is in the future, the exact risk or loss isn't known when that contract is entered into, when that policy is issued. So all who are sharing in the risk, the insurer, the insured, view the risk as, quote-unquote, the probable amount of loss. And the amount of coverage and the premium for the insurance is actually purchased and calculated based on an unknown quantity. This is the nature of insurance. This is underwriting, and it's voodoo science for a lot of people outside the insurance industry and for many inside the industry. But the correct measurement and assessment of the loss potential is the foundation of any system of insurance. And this assessment is accomplished only through a very careful analysis of prior experience, experience modifiers. There's mathematics involved with chance, and the likelihood that any loss will be recouped through subrogation is and should also be factored into that premium. So the subrogation efforts that we're going to be talking about benefit both the insurer and the insured, and they also benefit society, which is, I think, a fact that is being lost by much of our judiciary these days. The interesting thing I'll comment about subrogation as we move into this, because it's worthy of protecting. If you're on the line, with this seminar, you have an interest in subrogation and recognize its value. Value to be protected if you're an insured, value to be protected and fostered if you're an insurer. But what we're seeing today is a lot of the trial lawyers, and basically we, be it the insurer or the insured, are going to be at odds a lot of times with the trial lawyers who, say in the case of workers' compensation subrogation, are going to be vying with us to obtain the lion's share of any tort recovery, and in many cases, all of the tort recovery. So subrogation is looked on by the trial lawyers as a anathema. It's an enemy, something to be defeated. But many times, judges also and legislators now, conservative Republicans, liberal Democrats, it doesn't matter, are starting to look at subrogation as something that, quote-unquote, just gets in the way. And so I spend a few minutes talking about the societal benefits of subrogation because in this market, at least for insurers, it's one of only two areas in which money actually comes into the insurance company. I mean, there's investments and there's subrogation and premiums, but the investments really aren't doing much these days, so subrogation has become a very significant line item in any insurance concern. Now, when we talk about subrogation, again, we talk about different lines of insurance: health insurance, auto, fleet, property, casualty, comp, bonds. But I always tell my clients that subrogation should be looked at as any effort to bring money into the company as a result of a loss. And that could include deductible reimbursements. It could include recovery of duplicate payments, contribution actions where you may settle a case with a potential claimant and then have a potential contribution claim against the ultimate tortfeasor, self-insured SIRs and large deductible programs, recovery of these deductibles. Any effort to get money into the company is something that should be considered part and parcel of the subrogation program. There are different types of subrogation, and as Chip and I talk about some of the obstacles and roadblocks to apportioning subrogation or to effecting it, it's important to understand the distinctions. The first type of subrogation, and the one that most people are familiar with, is contractual or conventional subrogation. This is, you look at your insurance policy, and lo and behold, in Section 6, Part B, it says right to recover from others, and it mentions that you, the insurer, have a right to recover or be reimbursed for any benefits you pay should the insured recover from a third party who caused the loss. It may go on further to say that you can compromise or waive this right prior to a loss, and you can waive it after a loss if there's consideration, if you get a waiver of subrogation endorsement, and we're going to talk about waivers a little later. So contractual conventional subrogation is the classic subrogation right that will arise from an insurance policy. Second, there's equitable or legal subrogation, and as I mentioned earlier, this is subrogation that just happens magically. You don't have to have language in your policy. Most states recognize equitable subrogation, and a good number of states give it priority, even if there's no conventional or contractual right of subrogation. Just by virtue of having paid a claim, you are automatically entitled to step into the shoes of the insured, if you're an insurer, to recover or seek reimbursement from the third party. And lastly, there's statutory subrogation, and those who are involved in risk management or involved with workers' compensation, it's interesting to note that there are several different types of statutory subrogation. Workers' compensation subrogation is just one. Medicare has a giant super lien that it can impose upon third-party recoveries. There are various other statutes that grant subrogation rights, especially to government entities. But the interesting thing about statutory subrogation is that it is set forth in writing by a state legislature or Congress, and it is much different than the other two types of subrogation because statutory subrogation, take, for example, workers' compensation. When an injured worker sues a tortfeasor for causing a work-related loss for which a comp carrier has paid benefits, that worker has the right to sue the tortfeasor, but the carrier also has the right to be reimbursed for all benefits it's paid. And there are many jurisdictions, Wisconsin is just one of many, that indicate that it is not technically subrogation. It is a statutory right of reimbursement. Regardless of facts, you have a right to recover that money because, at least in the case of workers' compensation, we've made a social pact. You, the employer, why in the world would you, of all people, have to be responsible for literally and potentially millions of dollars in medical expenses and lifetime round-the-clock care for a catastrophically injured employee who was tragically injured through no fault of your own? Well, that decision was made back at the beginning of the 20th century when we said in our society we want to make sure that employees are covered when they are injured, and therefore we're going to give the employee immunity from being sued in exchange for an obligation to pay any and all medicals related to a work-related injury, irrespective of whether or not that injury was caused by the employer's negligence. Now, what we are seeing is that little tit for tat. Employer is going to be responsible to pay the employee's medical benefits and lost wages. In exchange, it gets immunity, and it has the right to recover that money back. That social pact is being eroded in many states, mainly states like Illinois and Minnesota, that allow contribution claims against a negligent employer because it feels right. But many legislators and judges are forgetting the pact that we made. So statutory subrogation is, again, something a little bit different than the first two. With regard to some of the tools that are going to be used by policyholders to try and bootstrap themselves up into a position of preference when it comes to apportioning a subrogation recovery, or tools that will be used by trial lawyers, plaintiffs' attorneys around the country who make a living suing people. These are some of the more prominent tools that states give them. There are limitations placed on subrogation rights. And a few of them are, let's talk about anti-subrogation laws. Some of the tools include the collateral source doctrine, the collateral source rule, which basically says that if a plaintiff in a personal injury lawsuit has recovered benefits from a collateral source, that could be a health insurance plan, workers' compensation, it could be a state auto plan, it could be no-fault benefits from a state auto policy. If collateral sources are recovered, the rule is that those sources will be ignored and the plaintiff can go ahead and recover. But there are exceptions, and states have their own versions of collateral source rules, which all have to be factored into the equations when you are settling a third-party case or apportioning subrogation. Many collateral source rules, New Jersey, Pennsylvania, and there are many others, are literally anti-subrogation statutes disguised as collateral source rules, and they basically say we're not going to allow subrogation because we want to make sure that the employee or the insured is first made whole. And that sort of brings us to the made whole doctrine, which is one of the more misunderstood concepts in American jurisprudence. And I say that because anybody who deals with subrogation understands that the made whole doctrine basically is a defense to the subrogation or reimbursement rights of a policyholder or self-insured. Before subrogation or reimbursement is allowed, the rule, the made whole doctrine, says the insured must be made whole for all its damages. And this is true in the case of property damage. Corporate insured suffers a catastrophic fire. Unless and until it's made whole, the made whole doctrine says that it shouldn't be that the insurer shouldn't be able to exercise its subrogation rights, be it equitable or contractual, before the insured is made whole. Put another way, the made whole doctrine says that absent and this is the way American jurisprudence categorizes the made-whole doctrine. Absent a contrary statutory law or a valid contractual obligation to the contrary, the general rule is that it is only after the insured has been fully compensated that the insurer acquires a right to subrogation. Now, I note that you pay attention to the words absent a valid contractual obligation to the contrary, because the made-whole doctrine can be successfully circumscribed around or contracted away in a growing number of states, Texas, Ohio, and others. I wrote the amicus brief in the Fortis versus Cantu case, which came out, I guess it was in 2009, Texas Supreme Court, which basically said, we have a made-whole doctrine in this state, but if your policy says you, the insurer, have a right to recover even if the insured isn't made whole, there are certain states which allow you to recover, notwithstanding that the insured hasn't been made whole. I would direct those of you who have an interest in some of this to take a look at our website, because it has a number of references and resources, including a chart on the made-whole doctrine in all 50 states. So you can go to the chart, look at a state, and find out whether or not that is a state in which you can contract around this rule that the insured has to be made whole. If you can't, then obviously, if the state follows through with a made-whole doctrine, it enforces it, then obviously you won't be able to subrogate. Other such resources include the statutes of limitations in all 50 states, MedPay PIP subrogation in all 50 states, the application of the economic loss doctrine in all 50 states, whether you can, landlord and tenants can subrogate against one another, parental responsibilities, work comp subrogation summary, what the law is in each state, just accidental occupational plans. It's just a nice source for some of these resources. But getting back to the made-whole doctrine, this becomes one of the most contentious points of difference between policyholders and the insurers, and I'm sure Chip will mention it when he talks about some of what he's going to be talking about. Equitable rights are different and separate from contractual obligations and rights, and this is one of the most misunderstood concepts, is that there are some states who say the made-whole doctrine, which is an equitable defense, should be applied to even non-equitable subrogation, i.e. contractual subrogation. Most or many states don't adhere to that, but some states do. There is a growing number of states, Georgia is one of them, that has legislatively mandated this, arguing that the made-whole doctrine should apply even to statutory subrogation, which has become quite problematical. But there's a growing number of states who are applying the made-whole doctrine or something like it. Now, keep in mind that all 50 states don't simply apply this across the board. Arizona has something called the doctrine of superior equities. California calls it the Ingebrigtsen rule. Florida says that the insured must be made whole before the insurer can participate in a recovery. And Hawaii applies the made-whole doctrine to UIM subrogation, but not traditional subrogation cases. Iowa calls it the full recovery rule. Louisiana calls it the full compensation rule. Maryland not only didn't adopt the made-whole doctrine, but it specifically disclaims it. Nevada first applied it in 2005, and North Dakota doesn't apply it at all. So you see, it really makes a big difference as to which states you're talking about when you're looking to apply the made-whole doctrine. Now, one of the concepts that I know Chip is going to be talking about, and we can discuss, is the concept of deductibles. As an insured, if you have a workers' comp or any sort of subrogation claim or insurance claim, and there's a deductible paid, if there is a subrogation right, when and where does the insured have to refund your deductible? One of the misconceptions that's applied globally across the country is that if a state follows the aforementioned made-whole doctrine, no matter what they refer to it as, that somehow the insurer has to refund the insured its deductible before it can enjoy any subrogation. And that isn't technically true. I think this concept that the insured must be totally reimbursed for its out-of-pocket deductible and any uninsured losses before a carrier can subrogate isn't actually true. The made-whole doctrine applies. Now, remember, we're talking about participating in a recovery. The made-whole doctrine applies when there is a sum of money that is recovered from a third-party tortfeasor that is now being competed over by the insured and the insurer. When you have that situation, you then have the application of the made-whole doctrine, which means that if the doctrine applies and if it is not in a state where you can circumscribe around it, and if the policy itself does not contract around it, then the insurer has to give up any subrogation aspirations unless and until the insured is made whole. There's an article on our website called Where's the Deductible? And there's also a chart on deductible reimbursement in all 50 states. And there are a lot of insurance regs and case decisions which say this is how we want deductibles reimbursed.
Gary, this is Chip. From a standard practical matter, how is it that the insurance company should make the policyholder aware of this doctrine in the states where it exists?
How should the insurer make the policyholder aware?
Right.
Well, I guess that begs the question, does the insurer have a duty to make the policyholder aware above and beyond the simple language that's contained in the insurance policy? In other words, if in the policy the insurer agrees that it's going to reimburse a deductible, well, it's contractually obligated to do that. If there's nothing mentioned in there, and if there is a recovery and the insured is saying, wait a second, insurer, I want my deductible back, you would just have to look to the applicable state law. But I guess my point, though, is that the made-whole doctrine itself doesn't govern the reimbursement of deductibles. There's a series of cases out of Florida and a couple of the federal circuits which go into this in some detail, that the made-whole doctrine shouldn't be used as a defensive weapon. In other words, it's only supposed to govern where the insurer and the insured are vying over a sum of money that's been recovered. Have you found differently, Chip?
Well, there has been in the past there has been a number of actually class actions that have been brought, with the argument being that there's been a failure to inform the policyholder of their rights, various rights with respect to actions against the third parties who are originally responsible for causing the harm to begin with, especially in property insurance, automobile accidents as well as other property claims. And you get into, and I think for the attorneys that are in the audience, I think, and this is part I'm going to raise, when you start representing one client, an insurance company, you start to run into conflicts of interest by not informing the policyholder, if you start into litigation agreements and things like that, of their potential rights that they have, because you're representing essentially multiple plaintiffs with competing interests. And there's a lot of very just practical concerns for attorneys, especially. I find this is a landmine sometimes when we get involved afterwards, and when a policyholder starts to question things. There might have even been an agreement that had already been entered into, and the policyholder was not informed of various legal rights and options and things like that, because the insurance company, as well as the insurance company's attorney, who's now representing both, failed to make some type of disclosures on that. So from a very practical standpoint, I always indicate, to this in these programs that if you're an attorney in various states, you really need to follow closely some ethical guidelines regarding representation of multiple parties who have competing interests. And typically it all comes out at the end when there is a favorable recovery, and they start, certainly from the policyholder standpoint, coming back and say, wait a minute, I'm entitled to more money than this, and you never informed me of my rights.
Sure, and Chip, I'm familiar with some of those cases and the resolution of them, and I happen to know that the two that I'm familiar with, at least, happened in jurisdictions where there are, even to this day, insurance regulations which require an insurer to take some action towards subrogation or bring a claim, and if they do, there's an obligation to reimburse the deductible. That's an affirmative obligation set forth either in the insurance regs or by case law. In states where there are no such regs, and those are set forth in the chart that's on our website, I think the result is different. I don't think that there just automatically, magically arises some duty on the part of the insurer to get a hold of its insured and say, oh, by the way, there may or may not be a right to recover your deductible. But that may be a point of difference, and I do know that it varies from jurisdiction to jurisdiction. One of the subjects as well that enters into the fray is the subject of a waiver of subrogation. And I did want to point out a couple of things. That waiver endorsements, remember, the right to subrogation is not the right owned by the insured. The insured may have a claim or a cause of action against whoever burned down his building, or if it's workers' compensation, whoever injured the employee. But the important thing is to remember is that the right to subrogation belongs to the insurer, not the policyholder. So who can then waive that right of subrogation? Now, again, law varies from state to state, but the right belongs to the insurer, so waiver of it can really only be obtained by the insurer. However, there are a lot of situations where indemnity clauses and hold harmless clauses by an insured effectively waives a claim or exculpates the defendant, and because the insurer steps into the shoes of the insured, its subrogation right can also be waived. But there is a difference between exculpation, where the insured releases a third-party tortfeasor in a construction contract, an AIA document, and an affirmative waiver where the insured comes to the policyholder and says, I would like a waiver endorsement in my policy, please. What's the additional premium? Oh, thank you for the waiver. There's a brand new case that in fact, it was this month, that came out of the Houston 11th District Court of Appeals in Houston, called Reliance Insurance Company versus Hibden. Now, it does stem from a workers' compensation claim, but here's the give and take, because it had both yin and yang for insurers and policyholders each. It was a contract between a company called RME Petroleum, who contracted with Gray Wolf Drilling to drill a well. Gray Wolf, as required by its contract, was obligated to get a waiver of subrogation in its workers' compensation policy with regard to all corporations or companies that it contracts with. It didn't, so it went out and got literally a waiver of subrogation as to any person or organization. The waiver of subrogation endorsement in the policy by which the carrier agreed to waive subrogation was as to any, quote, person or organization. And the employer was required to obtain this waiver, but the actual waiver only named the company. It didn't name the particular employee of the third-party company, and so the plaintiff proceeded to sue, and the carrier proceeded to claim a right of subrogation against the individual employee, and the court said that was okay. Even though there was a waiver of subrogation, the waiver wasn't specific enough to prevent that cause of action. But what was interesting and troubling for policyholders in this case was that this was a large deductible policy. Gray Wolf had a policy with a $250,000 deductible from Reliance, and as a result, it actually reimbursed that deductible. So when Reliance sued in subrogation, the court said, no, you've already been reimbursed. You don't have a cause of action. Well, so Gray Wolf said, well, wait a second, but don't I have a cause of action? And the trick in Texas is that no, only the insurer, the work comp carrier, has a right of subrogation. It's one of the few states that does not grant that subrogation right to the employer. So it really was a yin and yang. Yes, they could subrogate even though there was a waiver of subrogation, but no, they weren't going to be able to maintain the subrogation cause of action because the deductible had already been reimbursed. When you have employer negligence, that's also a problem that crops up from time to time. Some of the classic enemies of subrogation, just to summarize on who your enemies are going to be. I mean, it's the trial lawyers who are going to be vying to destroy subrogation rights, the American Association for Justice, which I've been a member of for 20-some years. Even though I represent insurance companies, I get their emails all the time, and they're always chock full of ideas and ways to destroy subrogation rights. Some of the popular arguments against subrogation are, and these are carrying a lot of weight in courts and in legislatures, hey, you guys, you paid a premium, you're paid a premium to assume this risk. Why in the world should you be allowed to recover after you paid that premium? Isn't it kind of a double recovery for you, the insurer? And then, of course, the notion that the insured should always be made whole are very popular in terms of anti-subrogation arguments. So I may have some more comments, but I know Chip is going to be discussing some items of interest relating to this that particularly the policyholders will have an interest in, and I'll let him take over at this point.
Well, and there is a bit of a difference in terms of philosophy that policyholders have when it comes to subrogation, and that's because they do want to be made whole, and like most clients, they want to be made possibly even more than whole. And as you go through all these, various legal theories from the policyholder standpoint, it's primarily the concern of how much money do we get, and what's going to be the agreement between the insured and the insurer when the money gets distributed. And I typically indicate to most clients that come to me before the subrogation is started by the insurance company, their actions by the insurance company to get it against the wrongdoer is to categorize all the uncompensated amount of damages that you're going to have. And the typical rule of thumb I go is in any sharing agreement, the larger the potential of the recovery, the more that you want to push with respect to rights that you might have, using some of what I love how Gary says anti-subrogation doctrines. I don't quite look at them that way. I look at them as the recovery of various types of items that you might be out. And of course, in today's modern society, policyholders are typically getting larger and larger deductibles. Insurance companies are pushing for percentage deductibles of the self-insured retentions are becoming larger. And as you go through the insurance policy, especially on property insurance, it's amazing how many types of losses or portions of losses are also not covered. And so what we're getting is a situation that's different than we had 30 or 40 years ago, when many losses were deductibles of $500 or $1,000, and you start finding policyholders almost with self-insurance through SIRs with $500,000, $1 million, $5 million, $10 million, depending upon the size of the corporation with respect to retention. Then we get into the other area where there's only partial coverages. So things are being excluded with respect to what the insurance company is liable to be paid. We have mold exclusions in insurance policies, asbestos exclusions. There's limitations with respect to the recovery of economic damages, both business interruption, extra expense, as well as other ancillary matters. So the policyholder is being left with a loss that is more than the deductible, but it's caused because of the way the product is written. They only have partial coverage. Certainly coming back and a concern of the society, and I think it's an appropriate concern, Gary, that you raised, and that is one of double recovery. The collateral source rule traditionally has been one that is applied typically with respect to the wrongdoer not getting the benefit of the wrongdoing, but being held accountable. And society has typically held the wrongdoer to be the party who is not going to have some type of windfall, that if there is to be any type of windfall, it would be on the person that is the victim of the wrongdoer's actions, as well as the person that had the foresight to go ahead and obtain insurance that frankly might even mitigate the amount of damage and the responsibility or accountability that the wrongdoer would otherwise face. So I think there's some other theories with respect to the collateral source rule and concerns about double recovery out there that sometimes aren't talked about. There is, in almost every single insurance policy, the policyholder has a duty to, and it says, cooperate. And I raise this quite often with the insurance company, because when you look at the definition of cooperation in any insurance policy, it doesn't mean slavish obedience to the requirements of the insurance company. Instead, when you look at it, cooperate in terms of a definition is one where there are two or more parties acting together for a common purpose. And we raise this very effectively, I think, with insurance companies when we enter into negotiations as to how it's going to be in terms of splitting of the pie when the money is recovered. If things go wrong, who's going to bear that particular risk, as well as who's going to control the litigation and determine when matters are going to get settled or not. But the cooperation is a two-way street. Many times we see it's being used just as a one-way street by the insurance company. It's not uncommon for us to be brought into a situation where the policyholder is being threatened by the insurance company or its attorney that if they fail to cooperate, they're going to come back and seek money back from the payment that had already been made as a result of the breach of the policy. And while certainly an insured and any policyholder should cooperate with respect to the insurance company's requests regarding subrogation and the litigation that goes on, because it's required contractually and probably required equitably as well as you start reading the cases, cooperation is a two-way street, and many people fail to use that. There is a concern, too, even before you start on the subrogation of, and this is from the policyholder standpoint, is that who is the subrogation going to be brought against? And many times the waivers of subrogation and the ability of an insurance company to go out and sue customers, tenants, others that the policyholder might do business with, many times can damage the interest of the policyholder. They're not the same, and those are considerations that should be made. They should be made even before the wrongdoing takes place, but certainly there are situations that come about afterwards, and those have got to be discussed because there is a conflict between the insurance company's desire to obtain money back and the policyholder's desire to maintain a long-term relationship that could be ruined as a result of litigation.
You know, I might jump in, Chip. I might just jump in, Chip, just to mention that this is a problem that's perplexing not only for policyholders but also for insureds. And I can tell you that my clients weigh these situations where, for example, a potential subrogation is against one of the main clients of the policyholder. In both a business and an economic sense, they look at the potential recovery and they look at the account. Quite candidly, there is no obligation that I know of which requires that if a third-party action is filed against tortfeasor, and that tortfeasor happens to have a contractual claim for indemnity back against the insured, which the insured will then have to pick up and defend, there's no requirement that the insurer drop its subrogation rights, but clearly, if it's going to affect a business relationship between the two and it's a good account and somebody who's actively being written, they may not want to pursue that.
And these are the types of things that I'm going to suggest, because just from a very practical standpoint, those attorneys who represent insurance companies and go out and this is the typical pattern. A loss happens, you get a telephone call from your insurance company client. The first thing you do is you send out the experts, you start preserving evidence, which is extraordinarily important. There has got to be programs, and Gary, I know in the presentation we talked about this particular area of the preservation of evidence is key with respect to many subrogation actions, because they won't get off first base. But after that scenario is done, it looks like there's a subrogation action that could be brought against the wrongdoer. Then the insurance company typically retains counsel to represent its interest, and then this is when we see unilateral contracts being sent from that particular attorney in terms of representation agreements and agreements to policyholders. And again, it's at that critical juncture that many of the bar associations, if they knew that this is what was going on by attorneys, they find it very similar to representing both two spouses in a divorce, representing multiple defendants in a criminal proceeding. it's very difficult to serve two masters with respect to these agreements. It's very difficult for you to, in a fiduciary-like capacity that you have as an attorney, to explain all the potential rights and do everything you could on behalf of one that is against the interest of another. And Gary, I don't know exactly how you address it in your law firm, but I find this ethical concern to be one that when we then get retained afterwards, or the policyholder comes and we see this litigation agreement and we go through, it's one of the first things I ask the client is what was told to you by the counsel for the insurance company at the time they drafted up this representation agreement. And I don't know if you can just waive those rights, but what do you do in those situations, Gary, where you're being asked and you're going to go hand in hand with the policyholder?
Well, clearly there are conflicts that can arise, and but I think we'll also acknowledge that these sort of cooperation agreements can be the solution to a lot of the competition between the insurer and the insured, who ideally should work together. There are a couple of questions I see coming down the pike here that have to do with large deductible cases and what arguments are made and how does everyone posture themselves when the made-whole argument enters into the picture of a large deductible recovery. But the more you can agree to up front in terms of that agreement, the better off you'll be. Usually pro rata agreements that say, look, no matter what's recovered, we're going to split it 25-75, sort of make a lot of those issues go away.
I would agree with that. I typically find, and I think one of the techniques that most successful attorneys find is, no matter what's recovered, and you make the deal on a pro rata basis. And then I think the second big thing after that is who controls the actual decision to settle or not to settle in that particular agreement. Those two things, the division, so you keep the policyholder or whoever is actively participating and with skin in the game, I think goes a long way to having a successful subrogation action, because an active policyholder, one who believes that they are going to get amounts back and they're going to participate along with it, can actually help the attorney out quite a bit on these cases. Without it, you can go ahead and lose your case because they just don't care or they don't have enough skin in the game to make it worth their while. I'm certain you find that all the time, Gary.
Yeah, absolutely.
Now, there are some issues with respect to apportionment, because sometimes we run into situations where the insurance company says, well, we're going to go on our own way, and then we start asking, well, wait a minute, the tortfeasor also has only one liability policy, and the amount of damages might be greater than that, and you're going to waste the liability claim back and forth. And what I mean by that, especially in this day and age where you get not just claims-made policies, but the defense costs are within the policy, so that a defendant might aggressively defend the particular matter. There's going to be less of indemnity dollars, so to speak, left afterwards, because the defense costs are wasting away the liability policy, many times caused as a result of my client's claim is less than what the liability policy would be, but once you add in the insurance company's payment, the total amount of damage is in excess of that, and there's issues as to whether or not and to what extent people want to collect on that. But looking at the amount of the tortfeasor's liability policy and their ability to pay any particular judgment is extraordinarily important, and oftentimes not looked at by the policyholder in consideration when you make these agreements up front. We typically, talk about not just, the apportionment, but who's also going to pay for the attorney's fees and costs. And that is all negotiable in there. Who, if the insurance company is going to go after it, are they entitled to have pro rata distribution after attorney's fees and costs, or how's it going to go on that? What would happen if there is a bad result and there's a taxation of cost? Who's going to be responsible for those costs? And if I can get one practical thing out of this entire discussion, I think, is that the policyholder many times is in a very good position to negotiate these up front. And if you can do it in such a way, especially if you don't have that much of a deductible, that you don't have that much skin in the game, what I typically try to sell to the insurance company is that the participation of my client is going to be, needed, and you're going to need my client's time, and my client's time, many times the policy doesn't say, who's going to pay for my client's time and helping for this cooperation. We start pushing very, very hard for my client to have a greater skin in the game and make up these litigation agreements that are to the policyholder's benefit. And again, then doing it hand in hand with the insurance company. So it is truly a win-win situation, but many of these things go unnegotiated. And if I don't mean to scare anybody out there, but typically the policyholder doesn't know this. Many of the attorneys who represent the policyholder don't know that these things can be negotiated because there's nowhere in the insurance policy typically where this is set out as to how the split's going to occur, who's going to control the litigation, what the rights are, and things like that. It's kind of an open season with respect to bringing and raising these particular rights for the policyholder, and they should be before the subrogation action begins.
Let me jump in, Chip, and I hope this isn't breaking protocol, but Herbert Ray with Kiesel Young Logan has a question that ties in precisely with what you're talking about. He says, in a large deductible case, what arguments do insurer and insured typically make with respect to the made whole rule, ? And then secondly, are there any leading cases in states without a controlling statute or regulation? And then lastly, if a recovery is allocated between the insurer and the insured, what rules govern the payment of fees and costs incurred to obtain the recovery? And I can answer that by saying what Chip just said really should resound loudly, because although the common fund doctrine has to do with when a party recovers a sum of money that someone else then benefits from. Typically, a trial lawyer, a plaintiff's attorney will recover $1 million, and the insurance company is subrogated out of that $1 million, but it owes a pro rata share of costs and fees to compensate the attorney for the work he did in making that sum of money available. In the question that Herbert is asking, it's a little different. You now have a large deductible policy. You have the insured and insurer who are proceeding, and there's a recovery. And how do the fees and costs get allocated? Well, unless it's specifically set forth in a deductible agreement or an SIR agreement, we're left with exactly what Chip is talking about. We have to, and it's best to get a lot of these things pressed into the form of an agreement that everyone's in agreement with up front, because those are going to come back to haunt us. And I'll just quickly answer the first question that he had, and that is that with regard to the made whole issue in a case like that, this is classic made whole. This is a situation where the insurer, with a large deductible that it wants back, and the insurer, who has paid the rest of the claim, are going to vie over, arguably, a limited sum of money. If there's more than enough money for everybody, it doesn't matter. Made whole doesn't even come into play. But if there's a limited sum, policy limits out there, a $100,000 policy, and insurer versus insured, in most states, the insured is going to win, because the made whole doctrine, if applicable, and again, if not contracted around in the policy in a state which allows that to happen, the insured will have a right to be made whole before the insurer can recover.
And I agree 100%. The main thing is, from the policyholder standpoint, these are all negotiable items, and you don't want to. I've seen the situation where people press too hard with respect to their rights, and the insurance company just forget it. We're not going to go forward, which isn't necessarily what the policyholder wants to hear anyway. Because typically, what the policyholder gets is a free legal team pressing with respect to the rights, and the recovery of monies back that many times are just completely written off. Certainly policyholders shouldn't look at it that way, the same way insurance companies shouldn't look at it that way. This is just free money coming back. But the truth of the matter is that if pressed, most insurance companies will back down on these in most states because of these. There are various issues. It's not just the deductible issue. It's not just parts of the matter aren't covered, but who's going to pay for the cost going through. Various issues almost on a checklist that I just discussed as we went through that will determine how much the policyholder will get back if there is a successful subrogation. Are there more questions? Do we have more questions there?
Gary and Chip, will you read? Gary, you picked up the questions there?
Actually, I have to tell you, my battery died in my headset mic. I just got disconnected, but I astutely dialed back in, so I'm back in now.
Okay. All right. Well, let me...
the questions that are in the...
Let me get to the Q&A session. Chip, did you have anything else you wanted to add before we start off the Q&A?
I really felt that, from the policyholder standpoint, I just cannot strongly enough indicate that these litigation agreements are key and how much power the policyholder truly has at the time of entering into these litigation agreements with respect to making a deal that can be extraordinarily favorable to the policyholder, especially if the insurance company has what it perceives to be a very strong case.
I will echo that and accent it by reminding everybody that one of the reasons that there is so much leverage for the policyholder in that situation is the prospect of the made-whole argument, which is an all-or-nothing prospect. And then the made-whole argument says, look, if the insured isn't made whole, you insurer get zero, zip, nada. And that can be pretty daunting. So it's really in the insurer's best interest to work with the policyholder and strike some sort of an agreement up front.
And, Chip, you do recommend that the policyholder get separate counsel for this.
I think.
If you could speak to something about that, because I thought.
We've actually in some of these situations, we've brought out what the bar requirements are in most states, and typically, I think the appropriate step for most attorneys is to indicate that you need separate counsel at the time of entering into this subrogation agreement. I think the failure to do so is probably a breach of the ethical standards with respect to attorneys, because you can't fully tell somebody who you're going to be representing in the future about all those rights, which might be adverse to the insurance company. And I think you're stuck trying to serve two masters at one time. And almost every single time that we've been brought in later, on this, and I raise this particular issue, both the insurer as well as their, counsel is now trying to represent both sides. I know are in a very difficult position. The truth is most regulations in most states require the adjuster to inform the policyholder after a loss of all their rights and benefits under the insurance policy. And all the rights and benefits. So we use that as well as with respect to an obligation of, and the states don't recognize good faith, but instead just looking at the regulations, well, you should be explaining to them their rights that they have with respect to subrogation, and you failed to do so. And I just think the better practice, and what I would suggest is, what we would strongly urge you to do is go get separate counsel, and let's work out an agreement that's a win-win for both of us, and that we can go on, and so that you don't have these problems, arise in the future, because they're ticking time bombs, quite frankly. I don't think anybody would want to be in a position where an attorney like me was asking these very difficult questions, afterwards. And yet we see it go on. I think it's more of the practice that most of the time, most subrogation law firms don't indicate this, or the insurance company doesn't, indicate the various rights that the policyholder has in their subrogation agreements or loan agreements. We've seen everything go through, and there's problems that arise that could otherwise have been avoided.
Yeah, I'd agree. It looks like Rita Barker, her question was right along those lines. Maybe that was the question you were answering. But she says, do you see any conflict in representing an insured who provides an assignment of all of his claims to an insurer and then representing that insurer once the assignment has been made? And that's really not much different than the classic subrogation situation. And I would agree with Chip that that is a problem. Now, having said that, if you were dealing with a small amount of money, I think practicalities enter into the situation, and I don't necessarily think it's necessary for an insured to run out and get separate counsel on every single situation, but I can't disagree with what Chip has said.
Wonderful. Well, audience, we've answered some of the questions. We're going to continue to do so. So let me tell you, the Q&A session, you can ask a question live if you'd like, and to ask a question live, please press 1 on your touchtone. That's *1, and you can ask a question live. You can also type in a question at the chat function, or you can email it to insurancelaw@stratfordpub.com. And before we continue with the questions, I do have to announce that We have a brief announcement. Many states require that you record and report the following code in order to obtain CLE credits for the live or recorded version of the CLE webinar. If you will be requesting CLE credits for this seminar, please write this code down on your attendance form. The code is TLUINE. That's Tango, Lima, Uniform, India, November, Echo. TLUINE. Tango, Lima, Uniform, India, November, Echo. And you can write that on your attendance form. And again, if you'd like to ask a question live, please do so by pressing *1, and the operator will unmute you one at a time. You can email your questions to insurancelaw@stratfordpub.com, or you can type your questions into the chat box at the lower left-hand corner of the screen and just click the blue icon. And let me look in the box here. Gary, I know you brought up a couple, so tell me if I'm repeating, because I don't want to do that. And the question we have here is, in a large deductible case, what arguments do insurer...
We covered that one.
We did one, okay.
Yeah. The next one I see is that of Jack Berkowitz.
Okay, yeah. Does the right of subrogation only arise upon the coverage of damages by the insurer? Here's the scenario. If an insured releases a tortfeasor prior to seeking coverage from an insured, has there been an impairment of the right of subrogation? Or is there no impairment because at the time of the release no payment had been made by the insurer?
Well, I'll answer, at least I'll go down that road, because I've unfortunately had that situation, and depending upon what state you are in policy, that can be a big no-no by a policyholder giving that waiver of subrogation. There are cases out there where it's indicated that's a violation of the insurance policy. It's a post-loss obligation that's been violated, and in some states what's been indicated is that the insurance company is relieved then of actual payment. So, and not all states follow that, but that is an extraordinarily important time after the loss that policyholders don't waive subrogation rights that the insurance companies may eventually have. And Gary, I guess you can speak to it more, but from a practice standpoint, that's a red hair. That's not a red herring. That is a red flag area.
Well, it is a red flag for policyholders, and Chip is right that it is very, very state dependent. Normally, policies say you can waive losses prior to a loss, but you can waive subrogation prior to a loss. But you can't waive it after a loss. If I read the question right, we've had a loss, and then there is a waiver or a settlement, and then there is a claim. And if the insurer knows about the waiver, which it will eventually, it may be excused from making benefit payments under the policy because of the breach of that clause of the policy. But understand too that there are some states that require that there be actual prejudice. For example, if there's a waiver against a uninsured motorist who is judgment-proof, there are some states that say, okay, you may have waived subrogation, but there wasn't going to be any recovery anyway, so insure, you still have to make your payments. That's one caveat. And also, just as a note, a related note, now the tortfeasor who is doing the releasing isn't always blameless. If the tortfeasor, and this is true in 90% of the states, if the tortfeasor executes a release and releases the insured with full knowledge that there were benefit payments made and that the insurer may have a subrogation right, it may still be on the hook for subrogation, in which case there really is no prejudice, and the insured can argue, well, look, I may have settled with this guy before I made my claim against you, Mr. Insurer, but under Idaho law, you still have the right to go against the tortfeasor because he had full knowledge when he did it. So there's a couple of tricks and traps involved, but generally Chip is right.
Yeah, waivers of subrogation, waivers of contribution, and things like that. In the ISO form for the homeowners policy, it's both Section 1, the property section, and Section 2, the liability section, where it allows these waivers that are, and it says specifically pre-loss. The problem that we see sometimes where it comes up is on post-loss, and there's some bad cases out there for policyholders in some states, so it is an issue.
Now, Herbert Ray asks, how does the fact that the insured's deductible is greater than the insurer's payment effect application of the made whole rule absent a statute or regulation? Absent a statute or regulation, the problem may actually diffuse itself. In that situation, in barring any agreement in a insurance policy or deductible agreement or SIR agreement, the claim would actually belong to the insured in that situation. Its right to recover back its deductible should be set forth in the policy, and I wouldn't imagine that the made whole rule would even have to come up. I would think the policyholder would get its money back, and the insurer, who basically has just babysat the claim and hasn't really paid out any dollars, wouldn't be entitled to any subrogation. Chip, do you disagree?
No, that's the position we take, although I think Florida's gotten a little bit squirrely on that lately with some decisions that have, or at least one particular decision that came out, tending to indicate that the insurance company can go its own way and not look at deductible provisions if they don't have some type of litigation agreement. But again, this is a state-specific question that you have to take a look at, and if you're a personal lines automobile carrier, subrogation is extraordinarily important in terms of recovery. The dollars can add up huge over, given the amount of subrogation that can be out, that can be out there, and that $500 or $1,000 or even $100 issue, on a repetitive basis becomes a big dollar issue, and you should look, for that particular state, both the common laws and even regulations, as to how the disbursement's going to go. More and more, the trend I see is that many of these issues on subrogation are being placed statutorily in regulatory form. We even see it with respect to, after large catastrophes, FEMA making agreements with policyholders and who's going to control possible rights against third parties that may have added to the amount of damage and things like that. And so that you have even a third party getting into the subrogation interest, so to speak, that's with the insurance company as well. So, and these are all based on regulation. So it's very state specific. And I would strongly, Gary, you got one of the best websites I've ever seen on subrogation. I am not a subrogation specialist. I do a lot more coverage work than just that. But for everybody who's out there, I would strongly urge you to look at his website, because it goes state by state by state, answering most of these questions that are being asked.
Yeah, and if I could jump in too, I know Gary had mentioned on his website, Contracting Away the Made Whole Doctrine and the 50-state survey on subrogation and economic laws. Those are in those reference materials that I spoke to you about. If you guys go to the website under reference materials, or right here on the handouts, Gary's firm has been kind enough to let us post them here, so you can print them off here and then go to his website for more. And Chip has a bunch of information on there as well for the policyholders. So let's see. Go to the next question.
Stephanie Diamant, McCarter.
Yeah, do you want to read that, Gary?
Sure. How do you apportion recovery among more than one insurer? For example, a primary and excess carrier, where one insurer brings lawsuit to recover against third party and the other insurer does not participate in the litigation. Does it make a difference if the non-participating insurer declined to participate in the lawsuit? And does the non-participating insurer have a cause of action against the policyholder? Well, good question, and one of the things that Chip and I can say repeatedly in answer to every question, and it's almost universally true, is it depends on what state you're in. Texas has a great deal of litigation on apportioning recoveries and equitable contribution to subrogation between excess and primary carriers. And generally, the rule is, as I understand it, is Chip. What's been your experience, primary or excess?
The primary one, as a matter of fact, it starts to raise a whole, issue in there about, especially for a lot of self-insured retentions, being considered whether or not that is a self-insured retention is a primary insurance for subrogation purposes, and that issue every now and then comes up. And I would suggest for everybody listening, if you do have an interest and this comes up, when you have a large deductible, and many times it's called self-insured, and I think really self-insured means, well, you're really insured. It's not insurance at all, but there's the case Bordeaux versus American Safety. It's a Washington appellate decision of 2008, 186, Pacific 3rd, 1188, that goes through a discussion of primary versus excess, and it doesn't actually come up with an apportionment on it, but whether or not you're able to even bring the action itself. And I think that's an interesting question, and I from the policyholder standpoint, it just doesn't matter all that much to how the insurance companies among themselves are going to apportion any particular subrogation recovery. So honestly, Gary, I haven't had to worry about it. I'm not in a position to tell you which one would go first. Typically, the excess carrier doesn't even have to worry about payment and doing various duties until the primary policy pays in the full amount. And I'm not certain whether or not it would be the same type of principle in reverse with respect to subrogation, because typically they don't act in a pro rata basis. It's primary, excess, and excess. And that would be my thought, but I don't know any cases on point.
Yeah, and I don't do a lot of equitable subrogation between the excess and the primary carrier. I've seen a lot of cases where it's been done, but I would agree.
All right, next question. What can an insurer do to prevent a policyholder from caving in and settling with claimants in waiving indemnification rights?
Well, from my standpoint, I think that, and I've had this happen before, it's when insurance companies with good subrogation actions start to notice that a policyholder might start doing that, there's these threatening letters about the possibility of having to bring suit to go get the monies back that were paid and all that kind of. I think you probably want to avoid that in the event the policyholder then goes to an attorney like me that starts raising tough questions that are those ticking time bombs that are out there. But at the same time, I've got to be concerned about my client violating post-loss obligations that would, in fact, be breaches and could subject my client back to almost like a subrogation action or some type of action where the money's going to have to be returned, which isn't the one thing you want to do. I mean, typically you can't sue your own insured. There's two big exceptions. Number one, if a co-insured commits fraud or does something intentional to cause the loss, the courts seemingly in many jurisdictions are allowing those type of subrogation actions against an additional insured or a co-insured. And the second situation is on various type of equitable arguments. Insurance companies argue that the policyholder has breached the policy post-loss by entering into these things or failing to cooperate. So I take it very strongly. At the same time, the policyholder, if they get to an attorney, frankly, like me, and you have these ticking time bombs that are out there, you're going to have a problem. So, again, the practical answer to that is to get a written agreement with respect to the subrogation action as soon as you possibly can with the policyholder, and that's going to obligate the policyholder as to what their performance is going to be with respect to the subrogation. And if you're from the insurance company standpoint and you're paying for this and doing all this kind of stuff, typically they want to have the right to go ahead and settle the case and make that decision rather than leaving it in the hands of the policyholder.
I might also add that, a classic example of this problem would be a property damage case, apartment complex, and the policy or the insurer pays for the damage and then has a potential claim back against some third party, and the insured, the policyholder, just quick steps in and does a small dollar settlement, which the tortfeasor is eager to agree to, and a release is executed. One of the things you might do is to remind the third party that in many states, settling like that without taking into consideration the subrogation interest, while having knowledge of it, can subject the tortfeasor to double liability. And if you throw that card out there for everyone to look at, the tortfeasor would, and we're talking liability claims people here who are normally pretty conservative, might loathe or be hesitant to settle for a quick win like that when it knows that it might have to pony up some additional money.
That's a great point, placing the policy, especially in this day and age with a lot of claims-made policies, placing the wrongdoer on notice as soon as possible of the potential of the subrogation action, I think is important and is a great step to go and protect that interest. That would answer that question perfectly.
The next question, did we already handle this question? Does the right of subrogation only arise upon the coverage of damages by insurer?
I don't think so.
Scenario, if an insured releases a tortfeasor prior to seeking coverage from an insured, you can violate, as Chip says, the terms of the contract by destroying or impairing the insurer's subrogation rights even before a claim is made, because once you make the claim, then their right of subrogation will have been destroyed by virtue of the release, even though it was made prior to the claim being made. It sounds like a technicality, and I can kind of get by with this one because I didn't really have the carrier really didn't have any subrogation rights that were destroyed when I executed the release, but lo and behold, the very next day when I went and made a claim, there were subrogation rights which, alas, were destroyed. And again, there may be some law in different states which differs, but that's been my experience. Ralph DeSanto also asks, is there an exception to the enforcement of a waiver of subrogation clause in an insurance policy where the tortfeasor has acted with gross negligence? Not that I know of. There's only a few. I've tried to get some additional waivers instituted in states like Texas and Florida, and it takes the Texas Department of Insurance forever to sit there and work on this stuff. But there's only a few form endorsements that are out there that can be used, and to my knowledge, I've not seen one that has an exception for gross negligence. Chip?
No, I haven't. And defeating. I'm talking about various waivers of subrogation. There's even a lot of court cases where subrogation cases, in particular, where the indemnification agreements are beaten by the subrogating insurance carrier, and those indemnification agreements are typically written in pre-loss, many times in the landlord-tenant scenario, but. I have not seen one, particularly as you just addressed.
Muhammad Faridi with Patterson Belknap asks, does the made-whole doctrine bar subrogation when the insured has continuing damages? That's an interesting question. Does the made-whole doctrine bar subrogation when the insured has continuing damages? Well, the ultimate question is going to be, when the settlement is made, if there is a limited sum of money and the insurer and the insured are having to go to the mat over that sum of money, in states which employ the made-whole doctrine and where it has not been circumscribed around in the policy, the insured will win. It gets its damages paid for. Now, keep in mind that continuing damages, that could be a number of things, but when you settle a claim, damages can include future damages as well. If it can show by a preponderance of the evidence that, you can talk medical, future medical care, future lost wages, those are things which can be proven and recovered in a third-party case. And unless and until the insured recovers those damages, at least in a bodily injury situation, I would say the insurer, where everything else is in place, would be barred from recovering subrogation by the made-whole doctrine.
I would agree with that. Many times you run into some practical situations where there's a continuing loss of income for a business that might have had a catastrophe or something like that. And I think those are situations, especially where there's good subrogation actions, where I think the policyholder and the insurance company should get very close to one another with respect to the claim handling, because you could end up actually making the wrongdoer's defense by the insurance carrier taking a very hard line position in the determination of what the business income losses are going to be. I'm not suggesting that the insurance company should overpay a loss or should pay as a volunteer, but you better be careful with respect to the documentation of it, you could be making the tortfeasor's position for you that the damage is actually quite a bit less.
I do have a question here that came in via email. Gentlemen, in a declaratory judgment coverage dispute brought by an insurer with multiple insurer parties, what impact does the insured's release of claims against insurer A have on insurer B's rights of subrogation against insurer A? Do you need me to read that again?
I do.
Yeah, I'm sorry. In a declaratory judgment coverage dispute brought by an insurer with multiple insurer parties, what impact does the insured's release, the policyholder's release of claims against insurance company A have on insurance company B's rights of subrogation against insurance company A?
Okay, I think I understand that. And when you say against multiple insured, I'm assuming we're talking about multiple tortfeasors, A and B, and A is released, and there's still B out there who would be a joint tortfeasor. The answer to that question is going to be a little hard to answer because you think states are vary in their application of subrogation law. Just take a gander at some of the joint and several laws from state to state. Some states are joint and several, some are not, some are pure contrib, some are modified pure comparative. I would say that it would have no effect on the subrogation rights brought by with respect to Party B. Although there may be some indemnity in there that could create some circular indemnity problems. Chip, does that make sense?
Yeah, I typically look at it as straight contribution indemnification actions depending upon what the state is. Most states, the release of one party doesn't bar an action against the other. There's limits with respect to recovery in most states now so that you don't end up with a double recovery. There's rights to set off and things like that by the non-released party. But
yeah, and I think I would be absolutely certain to look carefully at the release language because a lot of releases contain language such as any and all parties or any and all affiliated parties or subsidiaries, and depending on the relationship between A and B, there may be some overlap from the first release in there if it's not drafted carefully.
Okay, gentlemen, we do have a live caller now. Elise, if you could bring the caller in and remind the caller to turn the speakers off.
Our caller is Elizabeth from Chicago, and if your speakers are on, please be sure to turn them off so that your question can be heard.
Hi, my name is Elizabeth Elmore. I actually submitted the last question, but I think something got lost in the translation. Wasn't about tortfeasors at all. Basically, if you've got multiple insurer parties in a case, and in addition to potential contribution claims, there are also subrogation claims against other insurers, and the insured releases all of its claims and dismisses all of its claims against one of the insurers, how does that impact the rights of the remaining insurers in the case as against the insurer that obtained the release?
So there's co-insurance on one insured?
There are, talk about, a declaratory judgment where there are injury occurring over multiple decades. So multiple insurers issued coverage.
Yeah. I don't know.
Okay.
This is one of those where my limited capacity, I'd have to draw a bunch of stick men on a yellow pad of paper. And, we've got several books we've written, one on work comp, subrogation, one on ERISA, and one on health, and we got one on auto in the works. The one that we have on fundamentals of insurance coverage is an environmental book, and it really focuses on coverage in environmental situations, which it sounds like this could easily be.
Yeah, I think environmental products liability.
Yeah, and I would have to look carefully at that. I don't know the answer off the top of my head. I don't know about Chip.
I don't know. Most courts, will go out of their way. Partial settlements are favored by most, courts. And is your question, in the event somebody does have a partial settlement with one of the insurers, whether or not that can be then used against the policyholder to avoid in the subrogating insurers with respect to the remaining ones?
Well, it seems like you could potentially waive other insurers' subrogation rights. The insured, by releasing claims against one insurer, could potentially be waiving other insurers' subrogation rights.
And that's how come I went back into the discussion where these discussions come in are typically in contribution claims of tortfeasors. I mean, that's about the only time I've ever seen it in terms of, if you waive it, it's to all of them. And Gary's right. I mean, you can get stuck in some jurisdictions where it says any and all, and reading those releases can be extraordinary, but most, in terms of, what judges are going to then look at, if it's tailored properly and just with respect to one defendant, to get rid of that one defendant, it would be, I would think, a stretch than to say, okay, if you waive all your actions against everybody else.
No, not the actions against everybody else, but all of the insurer's claims against the to-be-dismissed insurer, which typically might arise as contribution, but in certain jurisdictions, contribution only applies if you occupy the same layer in the same policy period as another insurer. So subrogation is an alternative to contribution in those circumstances.
Elizabeth, I would feel pretty comfortable if I was insurer B that I would still have a right of, and depending on the state, contribution. I mean, there are some states whose contribution laws don't necessarily premise the right on stepping into the shoes of the insured who is now released insurer A, but rather there's statutory apportionments in many states that simply say, look, this is how we're going to allocate, recoveries in a situation where there is co-insurance. And these statutes are growing. Look, if we have co-insurance on a single loss among insurers, here's what we're going to do. A, it's pro rata. B, you can then litigate to determine if someone owes more than the other. And I'm not quite sure that public policy would allow that insurer to simply release insurer B's right of contribution. Otherwise, you could do some pretty slick stuff.
Right.
By finagling a dollar settlement with insurer A and then going against an insurer with against.
Well, I think that's the sense. They wouldn't be able to waive a right of contribution, but if it was, my phone's, I don't know if that's coming through on your end or not. It seems to be fixed, but yeah, if it was contribution, they wouldn't be able to waive it. But if you were basing it on contractual subrogation, I think that was the concern, that a release of claims might impair other insurers' rights.
I guess the answer for me then is I don't know. I really don't know, and I've not come across a case involving exactly what your issue is, and as close as I've gotten to it being the contribution discussion, there's I can't think of any other context where the research would go.
Well, it looks like Elizabeth wins the prize. Alice, what do we have for Elizabeth?
Yeah, for stumping the speakers, Elizabeth.
sorry, and I'll back up.
No problem. I love it.
It's at least encouraging that nobody else thinks there's a simple, obvious answer that I've missed. So,
yeah. Okay, Elise, I don't have any other questions. Do you have any live callers? I don't think so, so I think I'm going to wrap this up. Thanks, Gary and Chip, for your very informative and lively discussion of these critical subrogation issues. And audience, we hope you've enjoyed our national webinar, Insurance Subrogation Challenges for Insurers and Policyholders. A webinar evaluation form will be emailed to attendees shortly. Please take a moment to fill out and submit the form to let us know how we did today. Listeners who have ordered or wish to order CLE credits must verify their participation in today's conference by submitting the completed attendance register that is part of the conference materials. It's on the handout page at the top right-hand corner. We will issue verification of CLE credits as they are granted by the states that accredit webinar events. If you have any questions about CLE credits for this program, please call our CLE service at area code 404-881-1141, extension 35. Today's participants can order a recorded version of this event at a special attendee price. You can call our customer service department at 1-800-926-7926, extension 10, or visit our website at www.stratfordpub.com. Please be sure to check Stratford's website for information on future Stratford CLE programs, including a seminar on additional insured coverage. Reconciling Business Contract Obligations and Policy Terms, and that is scheduled for December 1st at 1 p.m. Eastern Time. Stratford would like to thank you for your attendance and for joining us today. To end this call, simply hang up the phone. Thank you and goodbye.